Welcome to the Scaringi Law Lunch Break. This is your time of the day to learn a little bit about the law while you enjoy your lunch. Today on Capitol Hill, the House Intelligence Committee's impeachment inquiry hearing continues with the Democrat star witness, Lieutenant Colonel Alexander Vindman, a National Security Council official. Republican ranking member Devin Nunes asked Colonel Vindman to identify the two individuals not in the White House with whom he spoke about the July 25th phone call between President Trump and Ukrainian President Zelensky. Colonel Vindman identified the one individual as Deputy Assistant Secretary of State George Kent, but refused to identify the name of the other individual, and under continued questioning would only state that the second person with whom he spoke about the call worked in the intelligence community. Before Representative Nunes could continue his questioning, Democratic Chairman Adam Schiff intervened, stopped the questioning in order to, as he explained it, protect the whistleblower. Schiff then instructed the witness not to answer Representative Nunes' question if he believed it would reveal the identity of the whistleblower. Colonel Vindman chose not to answer the question then and not to identify the whistleblower. Well, does the alleged whistleblower have a legal right to have his name remain anonymous? And what about those who claim it is a crime to reveal the identity of the whistleblower? Are they correct? Is it a crime? Well, the answers are no and no. No, it's not a crime to reveal the identity of the whistleblower. Now, the Government Accountability Project states that revealing the identity of the whistleblower would violate 3 federal criminal statutes. Number 1, obstructing a congressional investigation is a felony. That's Title 18, Section 1505, and that's been on the books since 1948. It makes it a felony with 5 years imprisonment to engage in communications that, quote, endeavor to influence, obstruct, or impede any inquiry or investigation that's being had by either the House or any committee of either House or any joint committee of the Congress, end quote. Now, this is the statute, by the way, that former federal prosecutor Sunny Hostin, now a co-host of the afternoon talk show called The View, accused Donald Trump Jr. of violating when he sat for an interview there with the ladies of The View. Remember, Trump Jr. told Sunny she was wrong, and she famously replied, well, my law degree says I'm right. Who's right? Of course, Trump Jr. is right, and Sunny Hostin, the former federal prosecutor, is wrong on federal criminal law. That's a little scary. In any event, revealing the identity of the whistleblower is not an act to influence, obstruct, or impede any congressional hearing. How is knowing the whistleblower's name obstructing a congressional hearing? That's just nuts to say it is. What we have here on The View is Sunny Hostin, a former federal prosecutor, falsely accusing Donald Trump Jr. of committing a crime. By the way, that's defamation per se, but that's for another Scaringi Law lunch break. The second federal crime that some have cited in support for their position that revealing the whistleblower's name is a crime is tampering with a federal witness. It's an obstruction of justice related offense. It is a felony. It's Section 1512 of Title 18. It's been on the books since 1982. Now, among some analogous provisions, this particular section, tampering with a witness, makes it a felony with 20 years imprisonment when an individual persuades another person or attempts to do so or engages in misleading conduct toward another person with the intent to influence, delay, or prevent the testimony of any person in any official proceeding. First, it's not clear that the whistleblower is even a federal witness. He has not testified before the House Intelligence Committee in his public hearing phase. No public information has been released that he's ever testified before the House Intelligence Committee or any of the committees involved in this impeachment inquiry. So he is likely not even a witness, so he wouldn't be protected by the federal criminal statute against witness tampering. Secondly, asking an individual's name is not persuading him with the intent to delay or prevent his testimony in an official proceeding. It's just asking him his name. By the way, That is the very first thing every single witness does at every single hearing after being sworn in. The person in charge says to the witness, "State your name for the record, please." So if asking the alleged whistleblower his name or if revealing his name is the federal crime of tampering with a witness, then there should be about 1 million federal prosecutions going on every day against federal judges and federal prosecutors who ask each witness to state his name on the record. Now, the third criminal offense that some claim support their position that revealing the identity of the whistleblower is a federal crime. They're citing retaliation against a federal witness. Now, that's a felony. It's Section 1513 of the United States Crimes Code. It's been on the books since 1980. Now, it makes it a felony with 10 years imprisonment to retaliate or take any action harmful to any person, including interference with the lawful employment or livelihood of any person, for providing to a law enforcement officer any truthful information relating to the commission or possible commission of any federal offense. Is asking the whistleblower his name an act of retaliation, an act to harm him, interfering with his lawful employment? No, it's not. Anyone telling you that it is a federal crime to reveal or ask someone to reveal the name of the whistleblower is 100% wrong on the law. Now, regarding the alleged whistleblower in question, he's been identified as Eric Ciaramella. I think it is doubtful that he even qualifies as a whistleblower. Under the Whistleblower Protection Act of 1989, he must have come upon the alleged wrongful conduct in the course of his official duties. The matter must be an intelligence matter, and he must bring the whistleblower complaint through the proper procedures. However, he did not come about this information during the course of his official duties. He wasn't on the call. He wasn't involved in any of the actions described by the other witnesses. He simply overheard people talking about this. Eavesdropping or overhearing conversations standing around the office water cooler does not make that a part of your official job duty. So he's not a whistleblower. In any event, it's not an intelligence matter. Pausing the giving of aid to Ukraine is not an intelligence matter. It's a foreign policy or appropriations matter. It's not intelligence. And he also violated the Whistleblower Act by going to the Democrats on the House Intelligence Committee before he filed the complaint, which is a violation of the very act under which he seeks protection. So the whistleblower is not a whistleblower under the law. He's simply being called a whistleblower by the Democrats and the media. But let's assume for the sake of argument he is a whistleblower under the law. What does the Whistleblower Protection Act of 1989 do for him? Now, if the whistleblower follows the prescribed procedures, which he didn't, but let's say he did, then by making his complaint, he cannot be punished by his superiors as reprisal. That includes disciplinary action like being fired or demoted or being given significantly worse responsibilities or working conditions. Also, intelligence officers may also not lose their security clearances by making the whistleblower complaint. That's it. It does not confer upon him the right not to have his identity exposed, revealed, ever, or by anyone. It does prohibit the Inspector General from revealing his identity, but it does not prohibit Representative Adam Schiff, Colonel Vindman, or any of the others who have come into contact with him. Those men are perfectly free and within their legal right to reveal the name of the whistleblower. And the Inspector General has the legal right to do so too if he thinks doing so is unavoidable. So revealing the whistleblower's name is not a crime, and the whistleblower has no legal right to remain anonymous. Anyone telling you otherwise is just making things up. Well, that's all the time we have today for the Scaringi Law Lunch Break. I hope you learned a little bit about the law. Thanks for listening and enjoy your lunch.